When you, heaven forbid, have to use your handgun to defend yourself, and then the inevitable 911 call is necessary, what do you say? What do you say? This is what lawyers debate about, gun instructors debate about, politicians debate about. It relates back to the Second Amendment, obviously, at its core, and then it gets into other constitutional issues. What are the legally significant aspects of both concealed carry laws and firearms laws? I'm also an attorney. I'm licensed here in Ohio and in Pennsylvania, so I'm wearing a couple of hats when I work with Golden, and that's what I'm going to cover. I'm going to focus on what are the criminal aspects associated with the post-self-defense shooting, and then what are some civil law aspects as well. Once you've defended your life using your handgun, that's a success, but you're not done defending yourself. Once that happens, you become a subject of the justice system, the legal system, and nobody's really interested in being your friend. Bob alluded to some of that when he mentioned how to deal with law enforcement officers. And the real theme I'm going for here is this concept of discretion. Being discreet as a concealed carrier is a good policy. As Bob mentioned, Ohio is both an open carry and concealed carry with permit state. You can walk down the street openly carrying. You're going to have somebody that objects to it and will call law enforcement on you. And being discreet is advisable, let's put it that way. That's the better advice. I'm starting at the top, Second Amendment. We're very unique in this country. There's really not too many countries that trust its citizens as much as the U.S. Here in Ohio, we have our version of the Second Amendment. You'll see the highlighted text there. The people have the right to bear arms for their defense and security. The interpretations of the federal version always talk about, gee, is that are we talking about an individual right or a collective right? And the Supreme Court has come down clearly in the last several years that it's an individual right, starting with District of Columbia versus Heller, and then McDonald versus City of Chicago, really confirming what was the individual right concept that was articulated by Justice Scalia in District of Columbia versus Heller. There's other rights I've left out of here. The Fourth Amendment also applies in this. But the post-attack, and I'm calling it post-attack, the attack upon you, you're going to be labeled after that as first the suspect, and then possibly a criminal defendant, and then after that, possibly a defendant in a civil lawsuit. So these are the sorts of things that it is also advisable for concealed carriers to be at least knowledgeable about. You don't have to be a walking expert on this, a walking encyclopedia on these things. But it is all one big ball of wax that the Founding Fathers had the wisdom to see into the future and realize these are the kinds of things that help us avoid tyranny, is the phrase they were using back then. Some pithy quotations from John Adams. There's that word again from 200 plus years ago. Arms in the hands of citizens may be used at individual discretion in private self-defense. That's what we're talking about here. And then James Madison, the Constitution preserves the advantages of being armed, which Americans possess over the people of almost every other nation where the governments are afraid to trust the people. It's nice to be trusted. We have a responsibility, a corresponding responsibility to earn that trust every day as concealed carriers. At a crime scene, though, that's where the discretion reaches its second step. You have to exercise knowledgeable discretion as a carrier. If, heaven forbid, you have to use the self-defense handgun, then other people's discretion enter the equation. And it starts with that law enforcement officer at the scene. And as I mentioned, you become a suspect and then criminal defendant and then a civil defendant. But LEOs, they have lots of responsibilities, and assuring you of your constitutional rights is not necessarily at the top of their priority list and their responsibility list. They've got other things on their hands. All they know is that there's been a shooting. They're not the judge. They're not going to come in and quietly listen to everybody and then make a decision about what to do next. They've got to render a scene safe. They've got to assist victims. They've got to identify and secure suspects. And when you've defended yourself, you're the suspect. This is a good general definition by a person who is an expert in this field, Masad Ayub. This is a name that wouldn't sound like a 30-year New Hampshire cop veteran, but that's exactly what he is. And he's one of the real gurus who was leading the charge for the concept of lethal self-defense as a valid version of self-defense in this country. And obviously he focuses on discretion as well. This is just a plug for him. I don't get a dime out of it. I've just read several of his pieces, and they're very, very good and very helpful. And he uses the word judicious in one of his classes, and look at the cost of that class. That's the kind of class where the whole classroom will be, as in the video, it will be filled with law enforcement people, but it's open to private citizens as well who are very serious about this stuff. But that book, the concealed carry book, he just came out with a recent edition. That's the one I happened to get most recently. A very good book when it comes to making decisions about how do you carry concealed, what sort of clothing do you wear. As I say to the kids at camp when we're working with our firearms and our archery equipment, we're all different shapes and sizes, so our equipment will fit onto us differently. And we all have to go through a trial and error process in finding out what works for us to truly carry concealed. Accidental displays, are not a crime in Ohio. But again, it's that cell phone that someone has near you that's going to have law enforcement showing up if you are less than completely discreet and judicious in the way you carry concealed. The Ohio Revised Code, we're going to get into the definitions of deadly force as it's defined in Ohio. Primarily, we're talking about the Chapter 2923 of the Revised Code, carrying concealed weapons. You'll notice that your license is a concealed handgun license. A handgun is one type of weapon. Your license focuses or is restricted to a handgun. And we'll talk about that a little more. And this is where we're going to get into slides. Don't strain your eyes too badly when we get into some of these text-heavy slides, because I'll be reading it for you. Openly carrying is valid in Ohio, but as I mentioned, it's going to get police interaction if somebody disagrees with the concept that is valid under Ohio law. So openly carrying is usually a poor choice. This is information from another attorney here in Ohio who focuses on firearms laws and concealed carry laws from a continuing legal ed class that I took, and he's a good resource as well. And so the conclusion is, don't carry openly unless there's some valid reason to. Often protests, legal protests where a group of firearms advocates are collecting and making a point. That's just about the limit of where you really want to be carrying openly, unless it's on your own property. If you have big acreage and you're out there and you need a gun for snakes and critters and roaming dogs, then openly carrying is probably fine there as well. But again, exercising your discretion, we have to do some thinking, more so than people who are not carrying a handgun. We have lots of duties. Concealed carrying do's and don'ts. There are prohibited places right now. We'll talk about some of the pending amendments in the Ohio legislature. School safety zones with some exceptions, court buildings, open air arenas that serve liquor or alcohol rather. And it says if, when, and what they're talking about there is you cannot be imbibing. That's what Officer Dave mentioned earlier. Public or private colleges and universities, except when it's locked in your car. That's why it was interesting for me to hear Officer Dave's comment about this type of lockbox you can put in your vehicle, because I occasionally lecture at universities and I bring my firearm, and it's a hassle to be having it on me, step out of my vehicle, then remove handgun, put it in the vehicle, lock the vehicle, go away, come back to my vehicle, because that's a vulnerable point. If there's a bad guy lurking in that parking lot, they're going to get you when you're getting out or getting into your vehicle, usually. And so the idea of being able to quickly pop into the vehicle and get that lockbox, I like a lot better than having to rummage around in a trunk or whatever else I might have to do with current technology. More do's and don'ts. Places of worship, those are prohibited unless it's okay with the place of worship. We recently had a member who called and inquired about this and did a lot of good self-educating. He had already talked to his pastor. He and several other of the patrons of that church were wondering, what do we do next? And we had a good online dialogue about, well, you're fine. Maybe you want to put it in writing. What you're really asking is a contract question. You want an explicit agreement with your place of worship, who the decision makers are, and they've told you they're fine with it. See if they'll put it in writing, whoever the ultimate decision maker is. That member was pretty happy with that concept of, we already know we have a good dialogue with our pastor. Let's see if they're willing to put it in writing. I don't know how that came out, but he was happy. It was kind enough to call us and say, hey, thank you, that helped us a lot. State government buildings and facilities, there is pending legislation to change that dividing line a little bit. And then other places prohibited by federal law, like post offices. Can't even drive onto the lot, all right? It isn't like universities and colleges in Ohio. It's a federal law. You can't even have it on the premises, even if you leave it in your vehicle, which it can be a hassle. I know that when I have a post office box rather than a mailbox, whenever I go to the post office, I can't carry. I have to leave my firearm at home. So I don't like that, but oh well, that's the way it is. More do's and don'ts. School safety zones, it's okay while you're dropping off your kids at school and when it stays in the vehicle. But if you hop out of the vehicle carrying, then you're violating the Ohio law. And then liquor serving facilities, as Officer Dave mentioned, it's okay as long as you have no drugs or alcohol in your system and that you don't imbibe while you're present at that place. And I mentioned the other guys were going to be talking about these things. They already have. Okay, we're going to talk about what is deadly force, because this is where we get into legal minutia for concealed carriers. As I mentioned, you're going to first be a suspect, and then you're going to be a alleged charged criminal, and depending on how far it goes, based upon the decision maker's discretion in that chain, it begins with the LEO, and then it goes to the prosecutor, and then if the prosecutor says green light, we're going to continue with the criminal charges, and we're going to try it. Then you're talking about a judge's and or a jury's discretion. But a handgun, you can pretty much, if you're using a handgun or you're carrying a handgun, that's deadly force under Ohio law. That's pretty straightforward. So deadly force, the definition under Ohio law, means any force that carries a substantial risk that it will proximately result in the death of any person. Reasonable self-defense and deadly force can be used to prevent what you reasonably perceive as a threat of serious imminent bodily harm or death. Your force and response must be quote unquote reasonable. This is related to the concept of discretion. Reasonable and necessary to prevent the danger, and that is determined on a fact-specific basis. That's where discretion comes in. And I like to think about proportionality. If someone's coming after me with a baseball bat, it's reasonable for me to conclude they are trying to imminently cause me severe bodily harm or death. So your handgun is an appropriate response in that scenario, but there's other scenarios where it may not be appropriate, and that's where we have to be well educated so that we can exercise our discretion in an appropriate manner. Burden of proof, that map is upside down on purpose, because in Ohio, we are the only state that puts the burden of proof on the defendant. In every other state, the burden of proof at trial regarding a defense, a legal defense of assertion of self-defense, that burden is upon the state to disprove that you have validly exercised self-defense. Here in Ohio, that burden is on the defendant, the person who has defended themselves by shooting someone in self-defense. It's a little different burden than beyond reasonable doubt. We'll talk about an example or two. Ohio requires that a defendant prove self-defense by a, quote, preponderance of the evidence. That is normally a threshold that you see in civil litigation, comparable to 51%. If a jury believes 51% that your case is the valid case, then in a civil proceeding, you would win in a civil case. In the criminal context, where it is the state's burden to prove beyond a reasonable doubt that you are guilty of a crime, you, in asserting your legal defense of valid self-defense, you have a burden, but not that strong burden of beyond reasonable doubt. Your evidentiary burden is merely preponderance of evidence. It's that can also be rebutted by the state in that same case. So here's another text-heavy one. So either don't bother reading and you'll hear me, or tune me out and read. With an affirmative defense, the defendant essentially concedes that the state can prove every element of the charge beyond a reasonable doubt, but that he should nevertheless not face criminal sanction for his conduct. He is arguing that his conduct was justified or privileged despite being nominally illegal. This is important for concealed carriers. This is important at the point of the 911 call. What is it you say or don't say? Fifth Amendment rights start to go out the window. Your right to remain silent tends to go out the window if you're going to hang your hat on, hey, I was defending myself validly. There's a lot of other defenses to the criminal charges that you have just removed from your quiver of arrows at trial. And that's why what you say and what you do at the scene is very important. That's why continuing education is important for concealed carriers. I need to be, just like we talk about muscle memory when Officer Day was talking about, you can't be sure when you're under duress that your fingers are going to open that safe correctly. Same concept applies. When you're shaking because your system has adrenaline coursing through it, and you're trying to speak to somebody that, hey, I still need help, even though I have rendered the threat, I have ended the threat, so to speak, my immediate threat. Boy, your system, your physical system is just going haywire right now. So you almost don't know what you're saying. And boy, that's tough to get that horse back in the corral after such an incident. Don't start your legal defense by limiting yourself to only the self-defense argument, because in the 911 call, if you say, hey, I shot someone who was attacking me, you've just eliminated a lot of other potential legal defenses at trial. And so Bob's advice earlier about here's what you say, you keep it fact-based. You don't bother telling your story. When the law enforcement officer shows up at the scene, well, we'll get into this in a little bit. Let's keep going with reasonable self-defense. There's 3 general conditions to establish that affirmative defense. You're not at fault, such as you didn't start a fight, and then the person escalated the fight, and then you escalated it one more time with your handgun. You don't have the affirmative defense of self-defense in that scenario. Your belief must be reasonable, and again, we're talking about discretion. Would a reasonable person feel the imminent threat of severe bodily harm or death? And also, you have to be in a scenario where you don't have a duty to retreat. Well, in Ohio, there is pending legislation that will change, that is proposing to change the line at which a duty to retreat does or does not exist. We'll talk about the Castle Doctrine now, revised code section 290105. Reasonable doubt in self-defense. A person is presumed to have acted in self-defense or defense of another when using defensive force that is intended or likely to cause death or great bodily harm to another if, that's the big if, the person against whom, that's you, against whom the defensive force is used, the person against whom, that's your attacker. The person against whom you use defensive force is in the process of unlawfully or without privilege to do so entering, or is unlawfully and without privilege to do so entered your residence or your vehicle. That is Ohio's castle doctrine. Right now, that is Ohio's castle doctrine. The presumption is a rebuttable presumption, as I mentioned, and it may be rebutted by a preponderance of the evidence, such as the assailant, the person who is attacking you, might also have the right to be in your vehicle or in your home. If it's a renter of a room in your home is one example. If it's a passenger who you initially invited into your vehicle to give them a ride and somehow they go crazy on you. These are some of the pending bills in the Ohio legislature. The last I have read, they're talking about trying to get a vote on one or more of these by the end of this calendar year. House Bill 231 expands the areas where a concealed handgun licensee is okay to include places of worship, daycares, private airplanes, government buildings, and college university campuses. It reduces offenses for carriers' mistakes from a felony to a misdemeanor. And it allows individual businesses to set their own policies regarding concealed handguns. Under House Bill 203, that's the castle doctrine one, it's expanding from the home and vehicle to any place that a person lawfully has the right to be. So, right now, if you're walking down the street and someone attacks you, you have a duty to retreat, all right? This bill proposes that you don't have a duty to retreat if you are lawfully in a place and you're abiding by the laws. And then Senate Bill 338 will reduce the concealed handgun license training from the current requirement of 12 hours with 2 hours of range time down to 8 hours. And it's eliminating, the way it's currently proposed, is eliminating a range competency requirement. Now that is a conundrum for NRA certified instructors. Many NRA instructors use NRA's 8-hour basic pistol course as the core of their 12-hour training. So you get 8 hours of the NRA course, 2 hours of range time, and say 2 hours of whatever else. When I teach a course, the whatever else is an abbreviated version of what you're getting now, covering Ohio laws and the do's and don'ts, which is covered in the Ohio concealed carry manual, which is often handed out at courses, but does everybody read that? All right, I'm going to guess the answer is no. How does an NRA certified instructor give an NRA certificate that a student has passed the NRA 8-hour basic pistol course, including its range competency requirement? How does an instructor give that certificate to someone to permit them to apply for their Ohio concealed carry license if there's no range time in their course? There's also the basic concept of, for me, I'm analogizing it to getting a driver's license. You want to make sure someone can actually drive a vehicle before you actually give them a license, because they're dangerous. You can kill someone driving a vehicle. Well, obviously handguns, and David was using the phrase validly, weapon. Of course, here in 4-H instruction, we never use the phrase weapon because we're talking about using firearms for sporting purposes and for educational purposes. The flip side is, here we are in a concealed carry class. We're absolutely talking about it as a weapon. It's a self-defense weapon. It's a concealed handgun license you acquire. A concealed handgun is a type of, quote, deadly weapon under Ohio law. Only one kind. There's lots of other kinds of deadly weapons under Ohio law. But so we're talking about a weapon when we're in the context of learning about concealed carry. I know that a third or more of every student I've ever had has never touched a handgun before. And here they are coming to get their concealed carry license. That's why Golden exists, or one of the reasons is ongoing, continuing adult education for concealed carry owners or concealed carry licensees, and for gun owners in general. So this is a weird one too. I don't agree with it. We'll see where it goes, but Ohio is on the stricter end of the spectrum when it comes to qualifying to carry a concealed handgun. So this is very interesting. I visited my mother in Portland, Oregon, and gave her informally the entire 8-hour NRA basic pistol course, but for the range time. And while I was there, researched Oregon law. Here's Oregon's requirement: 3-hour course, no range time, 1 hour of instruction, 2 hours of question and answer. That's the Oregon version of training necessary to apply for your concealed handgun license in Oregon. Next door in Pennsylvania, where I'm also licensed to practice law, there is no training requirement. You walk into the sheriff's office, and there's no reciprocity with Ohio, by the way, as a result of that. Walk into the sheriff's office, fill out the form, pay $25. They do a background check. They mail you your concealed handgun license in the mail. That's what I had to do as an Ohio concealed carry licensee, no reciprocity. So I live 15 miles west of the PA border. I drove over to Meadville in Crawford County and went through that process, and 2 weeks later they mailed me my Pennsylvania concealed carry license. So I can now drive over to the Walmart in Meadville and have my concealed handgun on me, just like the post office scenario. I had to, I'm going to PA. And I made a mistake every once in a while. I would, out of reflex, I would have my concealed handgun with me in a bag, a little ditty bag in the vehicle. And on my way there, over the border, oh my gosh, I just realized I went to PA, or I changed my plans. I intended to go to Walmart in Ohio, and then, no, I think what I need is over at that bigger super center in Meadville. Whoops, I have my handgun on me. That's not good. So right now it's a patchwork of laws. There has been a long buried federal proposed legislation of uniform reciprocity for concealed carry. Politicians aren't going to get behind that, and trying to fix that patchwork with that one big thing, that's tough to do in the federal legislature, especially the way it conducts business these days. Dangers of the law enforcement officer's discretion, in most cases of legitimate self-defense. The facts as gathered by investigative officers are sufficient to meet the defendant's burden of production. This is more legalese you're going to hear, as opposed to the burden of persuasion. It's enough for the burden of production on self-defense, but very often police reports are not accepted as valid evidence at trial. That's the other hassle too. So the concept of the law enforcement officer's discretion, determining your future, that's something you don't want to rely on, let's put it that way, because they've got other priorities. So here's the conundrum. Law enforcement officers do not appreciate silence from a suspect. That makes you even more suspicious. They're investigating a crime scene. They want to know stuff. They want answers. Suspects won't appreciate how prosecutors treat the statements you might make to the LEO or to the 911 dispatcher. Excited utterances, that's an exception to the hearsay rule at trial. If you're under the duress of just having shot somebody, and that's what you say on your 911 call, the prosecutor's going to argue that's an excited utterance. You can hear it in their voice on the 911 call. The judge says it comes in as evidence. That person just admitted that they thought they were shooting someone in self-defense. So we're not going to accept any arguments regarding any other legal defenses that criminal might have, that suspected criminal might have at trial. And this is my phrase at the bottom. Think of the justice system as a machine with gears that grind up suspects and defendants. You've already been labeled. You're a defendant. Nobody in the justice system really cares what happens to you per se. They just want to solve the riddle of how does this factual scenario fit under our laws. They're not interested in you as a person. The prosecutor's discretion involves what will the charges be? What is my menu to select from based on the fact pattern I have in the evidence before me? If they decide we think this person did this with malice aforethought, they didn't do it in self-defense, we're going to charge aggravated murder, life, or either death sentence in Ohio or life in prison. Plain murder, up to 99 years. Manslaughter, 20 years. Aggravated assault with deadly weapon, 20 years. Negligent homicide, 2 years in jail. That's the prosecutor's menu when they're thinking about what shall I charge? And prosecutors are measured on their convictions. So you can bet they're going to try to get as much off that menu as they can. Judicial discretion. This is an old phrase. I don't know where I got it. Sometimes cases are determined based upon what the judge had for breakfast. What's his attitude? And it's what Bob mentioned earlier. Cops are human, we're all human, we all make mistakes, we all wake up with a slightly different perspective every day of our lives. How will the judge's discretion be exercised? Who knows? Let's see. Carrying concealed weapons. No person with a concealed handgun license shall knowingly carry or have concealed on the person ready at hand any of the following: a deadly weapon other than a handgun. Your license is restricted to one handgun. And then a couple of other legal definitions go along with that. A handgun means any of the following: any firearm that is a short stock and is designed to be held and fired by the use of a single hand, and any combination of parts which can be readily assembled into a handgun. This is some of what Bob mentioned in what happens in a traffic stop. These are some of the problems or the charges that you will encounter if you fail to meet your obligation as a concealed handgun licensee. If you fail to tell the officer right away, it's a first-degree misdemeanor. If you fail to keep your hands in plain sight, it's a first-degree misdemeanor. Don't remove or attempt to remove the loaded handgun from the holster. That's a fifth-degree felony. Knowingly disregard or fail to comply with lawful orders, first-degree misdemeanor. Here's where we get into the civil aspect of things. After, let's say, you're exonerated at a criminal trial, you still have additional potential litigation to deal with in the form of civil lawsuits, tort lawsuits, based on negligence or something bigger, recklessness. Those are some of the other legal phrases. Wrongful death claims for relatives and spouses. When someone's death is caused by a wrongful act, which would have entitled the party injured to maintain the action and recover damages if they hadn't died, the person causing the death shall be liable in a tort action for damages. So this is a scenario, let's say you're charged with murder, but you're only convicted of manslaughter or something lesser. That gives surviving family members of your assailant an opportunity, a hook to hang their hat on, to come after you with a civil action, all right? Let's see, there's compensatory damages. This is where the dollar figures start to go way, way up. In a wrongful death action, loss of support, loss of services, loss of the society of the assailant who you killed in self-defense, loss of prospective inheritance and income from that person who you killed in self-defense, and the mental anguish of the surviving spouse and other relatives. There are caps on non-economic losses in a tort action except for wrongful death actions. So there's no cap on the damages. Let's say this person who assaulted you and you shot in self-defense and killed was a medical student, and they would have had a potential very lucrative career. Those are the sorts of things that plaintiffs' lawyers go and hire an economics expert to do some tricky math that talks about the millions of dollars that attacker might have earned had you not shot him in defending your own life. So these are the sorts of things that Golden also offers services to help you with in terms of providing you a legal defense. Those are some of the resources that I cited in this presentation. I realize that when you get to the legal stuff and you get to the heavy text, it can get a little it's tough to maintain your focus. So I appreciate your maintaining focus long enough. We did pretty well on timing. Okay, well, I think that's about it. Thank you, everybody.